they have treated not only with contempt. That was demonstrated and must be rated, paragraph 20D. Not images of breach, and it was time of the declaration of the final result. To that if at least is position shown on 34B, my lord, that is what the chairman must check 34B, their own admission, because the evaluation, what 1.5 days, in the end, my lord, from the chairman, all the two to admit that he to them that the law requires the third respondent got that in the public portal. But more importantly, that result must, it is clear IBC first in court. My learned friend Mr. Nyamodi says a figure that was formerly called provision. Now, these are supposed to be transmit inaccuracies and run away from it. But more interestingly, and sometimes this happens when you have many counsel, to the very basic question, were all the 34As transmitted eventually to the National Tallying Center? My learned friend Mr. Nyamodi says yes. Issa Mansour comes later and says no. The same IBC addressing you on such an important matter. The chairman must robotically pick them and pronounce without verifying. I submit, my lords, that that cannot be the position. But they transmitted these results. Given those very results, analyze the entries that were provided to you. Those people paid by the taxpayer, some of whom are already public officers, that this court, and lastly, and this is my closing on my part, issue and the question that my lords did 507 the question face their own documents is 4,000, their own documents. Number, my lord, is 5,528. To tell you that those numbers, which come to less than 9,000, is why the president, that the contempt and unseriousness. Thank you, my lord.
Thank you. Thank you, Mr. Chen.
Thank you, my lord.
Yes, Mr. Norwich.
Thank you, my lord. Members of the court, my lord, may Mr. Gatia's submission, he said that in that there was the provision to tally and then to declare the result. And he was referring to Article 138, 3, Sub-Article 3, Paragraph C. But he left out one very important part of that provision. And the provision is this: after counting the result, So that right in there, right in the presidential election special provisions, is the necessity for the returning officer, the second respondent, to verify before he declares. And we submit that this indeed was not done. We go a step further, my Lord, and we say it could not have been done. This is the important consideration that we wrote to the IBC on the 10th of August, the day of the result, and that is to be found. It has already been submitted by my learned friend, Honorable Otiende Amolo, in his submission. It is the letters are to be found in the Petitioner's Supporting Affidavit, Volume 1, Volume 2. I'm sorry, Volume 2. And at page 207, this is what we wrote to the IBC, saying, you informed the Kenyans and the world at large that IBC had received over 40,000 forms, 34A, and about 170 forms, 34B. We have requested IBC for all these forms for purposes of verification. Members of your secretariat have informed us that they can only avail 29,000 forms of 34A. So that is a gap of about 11,000 34As on the 10th of August. As at 11 p.m. of 10th August 2017, which is now after the result. So after the result, my Lord, 11,000 34As were not with the IBC. They could not avail them to us. Kindly request the Commission to expedite. Then the IBC didn't reply immediately to this, and on the 14th of August, we wrote again to the chairperson, which is on page 208, the next page, my lord, my ladies. This is a follow-up of our letter of 10th August. Until now, IBC has only furnished NASA with 29,000. So that is close to, my arithmetic isn't the best, 12,000. Forms 34A and 114. We urgently require the unsupplied 10,000 form 34As. So even between the 10th of August and the 14th of August, those missing 11,000 34As had not been supplied to us. We wrote this letter on the 14th. They replied then on page 209. To the Deputy Presidential Agent from the CEO, Commission Secretary, Mr. Chiloba. Reference is made to your letter of 14th August, requesting to be supplied with the remaining forms that were not supplied earlier. The Commission is in a position to provide all the requested form 34B immediately, so they could give 34Bs immediately. We are, however, not able to supply Form 34As at the moment, but the same shall be availed to you as soon as possible. My lords, my ladies, this is now 4 days after the result. If they do not have, those are not available. I use his words, they are not able to supply 34A at the moment. How then did he get to the result? I will come back to this aspect, but at this moment we submit, in reply to the submissions made on Article 38, that the returning officer, the second respondent, did not verify and therefore did not comply with Article 38, which is the article that the respondents themselves say it had been followed and is to be followed. And we say that this, therefore, could not lead to a result, and that the declaration of result was therefore in violation of Article 38 and could not give forth of a lawful result, a lawful declaration. I'll come back to these forms in a short while and turn then to the question, where were then these forms? Why were 11,034 A's missing for 5 days after the election? 6 days, actually. 6 days after the election. And we saw here a chart by the respondents of what happened at 5:07, what happened at 5:08, 9, 10, etc. What would have helped the court would be to have a chart of what happened step by step. Let us take the 34 A's in the best of conditions, my lord, giving them the benefit of any doubt. And 34 A's were supposed to come from these 40,000 polling stations to the tallying center and then from constituency to the national. And when they arrived there, presumably immediately after the counting, and my learned colleague, Mr. Molo, has pointed out, what were the means of transmission? That already creates another area of hopeless doubt, which has not been cleared. But let us assume that they were transmitted electronically, and when that predictably failed, they were going on with another system. But whatever it is, 34 A's had 41,034 A's had to reach the National Tallying Center. And they reached on that day. Maybe they reached on the 11th, on the 10th. My lords, then we do not know what happened to them. On the 14th, on the 11th, they're not there. 12th, they're not there. 13th, they're not there. 14th, they're not there. My lords, they have gone into the IEBC headquarters, and then we hear no more about them until later, and I come to that. My lords, there is in this mid-Atlantic Ocean, near Bermuda, an area where ships that have gone into this area never seem to come out, and nobody knows what happens to them. This is called the Bermuda Triangle. And the Bermuda Triangle is notorious for the absence of knowledge of what happens to ships that go into this triangle. My lords, we have emulated that, and this is the Bomas Triangle. 34 A's come in, and then they disappear. We don't know what happens to them. My lords, this is not law. This is not accuracy. This is not verifiability. This is not transparency. This is something, unfortunately, that can only give rise to a very questionable sequence. And it is this, my lord. Everybody knows, and the Honorable Mr. Kerry, who is a gallant and honorable person, himself thought that it was very simple. All you have to do, if there is a problem in the result, go back to the 34As and the discrepancy will come forward. And those people who have an interest in this, know that that's the purpose of 34A. We were closing gaps everywhere, loopholes were being closed. But, my lords, suppose you do the reverse. Instead of changing the result to the 34As, suppose you change the 34As to match the result which you have given. Then, when people go back to the 34As, the result, false result, and the 34As will match. But only, my lords, if they are false 34As. And, my lords, in order to have 41,000 false 34As, you need time. You need different
Sorry, my
papers.
lords, I know I'm not supposed to interject, but is that not a new case? Is that not a new angle in terms of changing the time?
Sorry, what's your
The issue is now, in terms of changing the time, my client has an interest because now you would need a time to change, that's what I'm hearing, the Form 34As to match, as it were, with the Forms 34Bs. Why I say that is that my client's agents were present when the signature was being done, or rather appended to the Form 34A. That's yes.
My Lord, he is not a party to this petition. He is not the custodian of the interests of either the person who's been declared, or the IBC, or the petitioner who is the candidate. He has no standing to make any interruption, my Lord. My Lord, I go back. So that the question is, you need time, and that is what may have happened. That is what could have happened, because, my lords, your lordships and your ladyships have no other evidence before you, and the only person who knows what was being done is the second respondent and the first respondent, and they have not chosen to explain this Boma's triangle missing, and the law, presumption in the law comes into place. A person who has special knowledge or the custody of evidence in his own hands and is not producing it to the court, the presumption is that the evidence he is holding is adverse to him. And that is the presumption that the court must draw in law, in common sense. My lords, your lordships and ladyships every day in your long careers sit and listen to lawyers and litigants coming before you and constantly twisting. But here is the question of hiding, and you all have enormous experience to know that litigants can do this and often do this. And you all would look beyond what is being put forward and say, what is actually going on? What is the common sense? What do we as people of the world see in this? And that is what is happening, we submit, that Form 34As were being held over for a purpose which can only be unlawful. I do not have to make any accusations, my lords, my ladies, against anyone. The mere fact of not disclosing what had happened to this can draw only one conclusion, that it is unlawful. And that is not a free and fair election. My lords, my ladies, not only did they not verify, but now we come to the other part of the evidence that Mr. Otiendo Amolo had brought forward. Why should there be forms 34A, which when put under the machine show different names? That some of them show a barcode, some don't. Some do show somebody else's use of these things. So why was this necessary? If these were original 34As, then there was no reason for the forms to be other than the forms of the IEBC. And secondly, there would be no reason for them to vary amongst themselves. One with this name, one with another name, one with a different code, one with a different name of the candidate, and so on. So that, my lord, the evidence that they themselves have given us, which we have now passed on to the court, shows, my lords, that this is a management of the election which is heavily unlawful in places. It is more than careless. This is not how elections ought to be anywhere near being carried out. And we submit that from this missing evidence, there can be no declaration of the result that can be lawful. And it goes a little step further, my lords and ladies. It is this. This type of presentation which the respondents have done on a long time is not at all unusual. And to stop that, to stop the chairperson, returning officer, tallying officers, to say, we got them, we put them together, and we announced them. That was exactly what happened in 2007. And it led to a predictable result. And, my lords, the law is, therefore, that when an election official makes an entry into any document, in this case, an entry into a declaration of result, he must have a belief in the truth of that entry, so that he cannot say what Mr. Honorable Kivitu said. Mr. Kivitu, do you think the President has won this election fairly? And he said, I don't know. On international television. And that is what they say, because, my lords, there is so much silence. Mr. Molo was right. They came and said the election was held with secret ballot. We had never said no, but they put it forward. We didn't do this. We had never said so. But they never come and say, we believed in this. Because they know that that statement in a court of law or in any other place is actually, my lord, an entry which does not carry that belief in the truth, is actually now a criminal offense under the Election Offences Act. We have not sought any such declaration from the court, but we are saying that a conduct by the returning officer, which is conduct which is forbidden by statute, is of itself unlawful. Whether he is charged, not charged, whether there has been a claim for it or not, it is an unlawful. It's an unlawful step taken by him. My lords, can this not only did he not say that he had any belief in it, but the question is, from the material, are there any reasonable grounds for believing that that result which was put in the entry and the entry then announced was reasonably grounded? My lords, we say, no. Even the facts before him, he himself knew, my lords, that over 10,034 A's were not available to him, even at 14th August, and certainly not on the 10th of August when he was announcing the result. And any returning officer, much less a presidential returning officer, who is announcing a result without the 10,034 A's, cannot reasonably believe in the truth of his entry. Secondly, my lords, if these primary documents, as has been said by the respondents, primary, and as Mr. Kerry thought, were the right place to check, if these are missing, my lords, can there be a genuine 34C? Because 34As go into 34B, create 34B, and 34Bs create 34C. How then was that entry made? If 34As were missing, 34Bs could not have been created, and 34Cs. And if 34Bs had been created with missing 34As, then one of two things: the 34As were present originally and then have gone missing, which creates a more serious doubt, and which a court cannot then disregard and confirm an announcement so that the head of our state would sit in his office on the foundations of an announcement which was built upon the primary documents to the extent of 10,000 being missing, or being unlawfully held, or being unlawfully treated, so that when the scrutiny comes, that circle closes correctly. But after there has been some doctoring, my lords, the electronic images of 34As were not sent when the 34Bs were sent. And all we got, my lords, was extensive explanation of the electoral law being changed and what happened in the IBC and what their discussions were. No, my lords, that does not explain anything. What is important, my lords, is that the 34B, they have admitted that 34A's images did not always reach the tallying office. My lords, there are a whole number of steps that were wrong or missing or not completed, but I emphasize these important ones and say what is then happening in relation to this. there cannot be then any reasonable grounds. If he himself has not said there are reasonable grounds, the court may look at his own grounds. The court may look at other aspects and see maybe there were reasonable grounds for him to do what he did. We submit quite the contrary. Not only are there no reasonable grounds for a true belief in that result, in fact, it raises suspicions which should never come from that institution itself. My lords, in relation to this then, I turn to some smaller aspects. The court had asked the issue of the dying declaration issue from the video there. My lord, it's of course not, as the court pointed out, not a dying declaration. But, my lords, if it is possible, may I draw the attention of the court to Section 33 of the Evidence Act, Cap 80. Statements by deceased persons made in the course of business. Here, so it says, when the statement was made by such person in the ordinary course of business, and in particular when it consists of an entry or memorandum or statements made by him in books or records kept in the ordinary course of business, or in the discharge of professional duty, or of acknowledgement written or signed by him for money, goods, etc., this same is admissible by Section 33. Here, it was made in his official capacity as an official of the IBC in the course of his normal business. Thank you. So that, my lord, it is admissible by virtue of the Evidence Act itself. Sorry. My lords, the submissions from the respondents were then aimed at saying, look, we've counted the votes, 2 and 2 make 4, and the gap is 500,000. Mr. Otiende Amolo has dealt with that, my lords. It is a concentration. Apart, your lordships will see when you weigh the submissions from the respondents, that it is concentrating on first procedural anomalies. Their affidavit is not this way, their affidavit is defective, the numbers are so small we added them up, the election was held with a secret ballot, etc., etc. My lords, there are more fundamental things that are wrong with the conduct of the first and second respondent and the benefit of that wrongdoing which is accrued to the third respondent. And they are putting forward numbers. The gap is so large. The test is, and my learned senior pointed out that they had taken all sorts of criteria, and the right criteria was that there should be wrongdoing and the numbers should be affected. My lord, numbers are not the only test. Not only is the statutory provision subject to the Constitution is very clear. There are other tests in this Constitution, and they are the tests in Article 86. My lords, it's known to you by heart, but whatever voting method is used, the system is simple, accurate, verifiable, secure. My lord, it should not be so secure that they keep the 34 A's for 5 days. Accountable and transparent. It was none of that, my lord. Then, my lords, it was submitted in this respect, that the numbers alone should be the test, because this is all about numbers. It is again in Article 81. There is another test. The whole of that article, my lords, that the electoral system shall comply with the following principles: free and fair elections which are administered in an impartial, neutral, efficient, accurate, and accountable manner. My lord, these are not the Constitution is not putting simply highfalutin principles. The Constitution is going down to 34A and down to the voting paper. Are you doing it accurately? And are you doing it in an accountable fashion? And are you doing it in an efficient fashion? Holding 34 A's for these number of days is neither efficient nor lawful, etc. Then, my lord, 38 itself, the voting, 138 itself, which was the third respondent's thing, also requires the same principles, that they shall tally and verify and then declare the result. And so, my lords, the tests which your lordships will apply to what is going on here, all placed before you. Where is the smoking gun? My lords, no person who is trying to manipulate or interfere with a process that gives rise to the highest power in the country is therefore waiting to give us the smoking gun and photographs of it and a video possibly. No, my lord, there is a bigger test. And the test is, who will benefit by all this wrongdoing? And has the second respondent, the first respondent, and the third respondent placed before you any material which can shift, not the burden of proof, my lord, shift the unavoidable conclusion that something wrong has gone seriously with this entire process? No, my lord, that is a more important test. And that is what has happened in this. My lords, I turn then, without in any way admitting the submissions of the respondents, to the question, my lord, to the submissions of my learned senior, Mr. Ahmed Nasir. My lords, it was my learned senior's submission, my lords, that you could only upset the result by if you found fault with the voter. 99%, he said, of these cases are with the fault of the voter. My lords, that is not correct. It's not correct factually. Firstly, my lords, it is not only, it's not any submission of ours that is at variance with this submission. The Constitution itself is in variance with this. Article 81, my lord, talks about, and this is very important, it says the electoral system, not the voting, not the counting, not the tallying. The electoral system shall comply with the following principles. So that, my lord, 81 does that. 86, so it's not only the voter, the whole system must be proper. 86, at every election, the Independent Electoral and Boundaries Commission shall ensure whatever voting method is used, the system is simple, accurate, verifiable, secure, accountable, and transparent. And see this duty, my lord, because it deals with the Form 34As as well. And the Commission shall ensure that D, paragraph D, appropriate structures and mechanisms to eliminate electoral malpractices are put in place, including the safekeeping of the election materials. That whole correspondence, my lord, is in breach of this article, this duty upon them, and they frivolously talk about that they came, and it is our fault, my lord. It's our fault because when the matter came before the registrar, the second respondent, the first respondent, my learned senior, Mr. Paul Muite, said, we offered to give them all these forms. And they said, no. My lords, they offered to give us these forms after the opportunity for malpractices was sufficient. They had already had time, and the matter came for directions much later, many days later after the result. So that righteously to offer us this, and said we were obsessed with these things, rightly so. And they said the numbers will be all right. With what confidence were they saying that the numbers will be all right? They didn't have that confidence on the 10th of August, nor when we wrote on the 11th, nor when we wrote on the 14th. But their confidence returns now. So that, my lords, we are not blind. We can also see. When a man goes into hospital, my lord, carried into the trolley, he says, my leg, my leg. And it may well be that in the end, the leg is all right. But the doctors find that, in fact, the ribs were broken, perforating parts of his internal organs. Then you don't go to that man and say, you came into this hospital claiming for a broken leg, and you're a charlatan, and you're on a fishing expedition, because you went into the hospital saying one thing and let the doctor search out what it was. My lords, these are not serious responses that come in. Secondly, my lords, I go to the issue of my learned friend, Mr. Ahmed Nasser, and that was a very important innovation in law that he made. He was supporting the issue of RILA 2013 and the reliance by your lordships on the Nigerian cases. And he said, what's wrong with that? Nigeria is a superpower. It's many times our GDP. My lord, this is a very important legal principle. I think that your lordships can take judicial notice that China's GDP is over 100 times ours, and the US is over 99 times, and I think you all should now go and get some Chinese cases and some more US cases, and then decide this. My lords, my learned senior will conclude the funeral procession and oration.
Mr. Noroji,
There's a question.
Oh, I'm sorry, my lord.
Before you sit,
Yes, my lord.
do you have any Chinese authorities for us?
I'm so sorry.
Thank you, my lord. And that's part of the high drama in this case. And it is from that that I want to begin the conclusion of the address on behalf of the two petitioners. My lords, we have not been short of drama in this case. It is learned counsel Ahmed Nasir who, raising the petition and pointing to your lordship that in this petition there is no cause of action, that it is nothing but fiction. In fact, it says it's science fiction. My lord, Mr. Ahmed Nasir and his colleagues have taken this court through 6 hours of a response to a science fiction. And my lord, if it was not a science fiction, I do not think that my learned friend, Mr. Ahmed Nasir, would have taken that amount of time together with his colleagues. And if you look at the cause of action, my lord, in terms of the petition and the pleadings, all the respondents have made responses to our pleadings and filed affidavits which ran into volumes. And again, I'm saying this, that if there was no case in the petition, these responses would not have been there. In fact, they should have taken the shortcut by making an application for striking out the petition. And having said that, my lord, there was also another very high drama in these proceedings, in which my learned friend, Mr. Pielo Lumumba, whom I respect very much, in fact, my lord, if it was terms of antiquity, I would have compared him to Cicero, who was a great lawyer and a great statesman. But my only problem, and I find it very difficult to respond to his submissions, is that the language of my learned friend, with respect, most of the time is a mélange. If you wish to say so in French, is a mixture of legal texts together with common prose. So I would never know whether he is responding, in terms of the language in which the law is written, or whether he wants me to also to respond similarly in the kind of prose which is definitely poetic and for which I respect him. But my lord, we have a definite question here. It is not about midwifery. It is about an election. Was there a free and fair election conducted by the first and second respondent? It's not about a baby. This is not a biological function or process. It's a legal process, and the product of which is a candidate who is declared a president. And by wanting to make that determination, you must go through not only the language of the text of the relevant legislation and the Constitution, but prove that indeed you have rendered an election in terms of the law. And which I want to point out from the case of Maina Kiai, which is a very important case in these proceedings and has been referred to many times. And I want to look at the penultimate paragraph of the case of Maina Kiai, which was Civil Appeal number 105 of 2017. And I think these conclusions are very important in trying to determine what type of responsibility we have in the conduct of these proceedings. And this is what the court said. The appellant, and that is the respondent in these proceedings, must in all these dealings be truly above suspicion and command the respect of the people of Kenya, for whom it acts. This is what the judges are saying, that they must be above suspicion and command the respect of the people of Kenya. There's a question of legitimacy also in this process. So at the end of the day, as Kenyans go back to their beds in the evening, go back, they go further and say, much depends on it. Indeed, the present and court is saying. It is not just about that particular electoral process which was under consideration, but it's the people who must have a good future and peace. And therefore, coming back to this, some of the findings in the minor case, minor Kai, my Lord, they put a lot of weight of transmission and determine why that mode was important. It's not that Mr. Nyamodi says here that the question of transmission is like a matatu. You can decide to take a matatu, take a bus, but the law prescribes which is the mode of transmission, which must be electronic. And the court gave a reason why this must be so. And they say this, having gone through the history, the context of what this country has gone through. And they say this in the judgment, and I quote, which I read in part, and warn myself that I may be selectively reading this judgment, as I must in the little time that I have. But they say this: the results announced at each polling station shall be transmitted to the constituency returning officer. It must be transmitted. And in another part of that judgment, they say that it must be an electronic transmission. And they give the reasons why this must be so. From my reading of all the provisions under review, the authorities relied on, and bearing in mind the history that we have set in detail in the judgment, we are convinced that the amendments to the Act were intended to cure the mischief identified by the then former chairperson of the appellant and other stakeholders. And this ranged from change of results between one level of election polling station to the county, to the constituency, rather the constituency, the county, to the national tallying center. So it was necessary right at the primary level of election, which are the polling station, that a transmission, an electronic transmission must be made of the prescribed forms so that there could be verifiability of the final tally of the results. And my Lord, my ladies, they say in another part, which will be the final part of this judgment, which I shall refer to, that pursuant to Section 45, subsection 5, aforesaid of the technology regulations, were promulgated to provide for, among other things, information security, data availability. And this is why this scrutiny that we ask for is very important: data availability, accuracy, integrity, confidentiality, and retention of the voting materials for 3 years following the elections. So, my Lord, what am I saying? My Lord, what I'm saying is that the issue of transmission by electronic means or conveyance is an important function in which this court must be satisfied that what was transmitted is what is provided for under the law. And the law says it is not the text. In fact, the question of text is not provided for under the law. The law requires that it is the forms, the prescribed forms are the ones which must be scanned and must be transmitted for purposes of verification and for purposes of accuracy and credibility. My Lord, I must end up by again saying this to your lordships and my ladies, that elections have winners and losers. Even in court, depending on the nature of the proceedings, there are winners or losers. But at the end of the day, the process is so important, so as much as the result. So that even in judicial proceedings, people are interested in the process. And for that matter, therefore, my Lord, I invite your lordships and my ladies that the question of the process and how the electoral process as laid out in the law and in the regulations was carried out is an important responsibility and function of this court. And I want to finalize by saying that if a proper scrutiny is carried out as the court has ordered, if everything available that the court has added to be availed to this court is brought before the court, your lordships and my ladies will find out that this election was a shambolic election. And with that, I thank you, my lords and my ladies.
May it please you, my Lord Chief Justice and the honorable judges of this court, I want to start first by thanking you very much for admitting me as amicus in these proceedings. I believe myself that this is a good tradition that should be followed into the future, that the Attorney of the Republic should have an opportunity to address the court on matters of great public interest, and I do thank you very much. Secondly, I want to reassure the court that I am consciously aware that no matter what I may say myself or my distinguished assistant, Mr. Mutinda, appearing with me, or Mr. Kaumba, the judgment of this court will be delivered by the judges of this court in accordance with the Constitution and the law. What I think I can do, my lords, and I will be asking you with your very kind permission, should I get very close to my 20 minutes, I will be asking you as a friend of the court itself for a little bit more time, but I think it may not be necessary. We wish, my lords, to share with you the benefit of our reflection on a number of issues that we have already framed, and I adapt in full the submissions we have filed, which is the amicus brief, and the 3 volumes of authorities that we have placed before you. My lords, the law requires the Attorney General of the Republic of Kenya to protect and uphold the rule of law. So I am here with my colleagues not to take sides with any of the protagonists who have engaged me for the last 1 year in a lot of litigation in the High Court, in the Court of Appeal, and I am now happy to see that this is the end of this journey and the matter will be in your safe hands. My Lord, I would like to start by making one point. To the question, in answer to the question that I have framed, that is the question, what is the constitutional and legal standard for the presidential election as envisaged in our Constitution? I want to start by saying, my lords, that there is a jurisprudence that has been urged here by the various parties that I myself do not accept to represent the jurisprudence of Kenya on the question of how you determine constitutional questions. And it is this. It has been suggested to my lords that when a question about the election of the president, for example, or probably all elections in general, is raised, then the court should go to the Constitution and the Constitution will yield an answer that is clear and that is determinative of the question. I want to suggest that that is not a proper approach. And I want to submit as follows. The Constitution is not an election statute. The Constitution is not an election statute. It contains the principles that should be observed in creating the electoral system. And to the extent that it is suggested by many of my learned friends here from both and sometimes multiple sides of these presentations, that the Constitution can yield an answer to whether the election was properly conducted, that is not true. What then is the truth? The truth is that the Constitution itself envisages that after it has set out all these broad principles, Parliament shall make a law. That is the language of Section 82. Section 82 of the Constitution itself recognizes that Parliament shall make a law. So, to where will a prudent lawyer go when he is confronted with a controversy as to whether an election has been properly or improperly conducted? A prudent lawyer will go both to the principles in Article 81 and 86. Then he will ask himself, what is the law that Parliament has made under Section 83? And that will be a whole range, and many of my colleagues have presented this to you. There will be the Election Act 2011, the Election Regulations 2012, the Election Technology Regulations 2017, the Parliamentary and County Election Petitions Regulations 2017, the campaign financing. It is a whole regime of law. So let me make my submission on this point. The correct jurisprudence is that the Constitution and the law must be read harmoniously, together. So in my very humble submission, a good lawyer will go to Article 81, go to Article 86, look at Article 83, then go to the entire regime of law. And let me add this, my lords, because I think this is another aspect of the new jurisprudence that I personally don't agree with. The Constitution is not a statute about affidavits. We have a statute about how affidavits are to be drawn. The Constitution is not a statute about evidence. We have a statute about evidence. The Constitution is not a statute regarding the procedure of the Supreme Court. We have a Supreme Court Act and Supreme Court rules. That's where a prudent lawyer will go to look for the procedure. I therefore would like to make the submission that this court must continue to resist an invitation to avoid clear black letter law, number one, to ignore clear black letter law, number one, and two, clear binding precedent. Because, my lords, if fidelity to law means anything, It means respect for the law. And no court, no jurist should purport to interpret a law by ignoring it. They used to say, my lords, in the old days, but patriotism was the last refuge of a scoundrel. These days, the spirit of the Constitution is the last refuge for a poor jurist. Where the Constitution speaks in clear and equivocal language, the court must find that that is what the drafters of the Constitution meant. Many people in this room are rightly very, very proud of the role they played in having this Constitution get to where we are now. And there are many on this side and as many on that side. But precisely, my lords, because we are so heavily invested in this Constitution, we must respect it. And the way to respect it is to remain faithful to its very clear terms where that is possible, and only to search for its spirit where there is ambiguity, where there is lack of clarity. But not to start with the spirit so that the spirit overrides the black letter of the Constitution. My lords, I can say this with tremendous respect. Whenever the court is invited to the spirit of the Constitution, it's being invited to decree a political preference of the party that is making the case. And I urge you not to agree to that. So what is the true test of how the election should be conducted according to the Attorney of the Republic and his two able assistants? It's a simple one. It's in paragraph 9 of our submissions. The court will ask itself a simple question. Was the election administered free and fair? Now, to determine whether it was free and fair, the Constitution would then look at the circumstances, which is impartiality, neutrality, efficiency, accuracy, and accountability. How will the court determine that? By reading the Constitution alongside the election law, not as two distinct bodies of law, but as one. It is one body of law. The Constitution, as the Bible says, begat the Election Act, and the Elections Act begat the election rules. They are not different. They are the same. I will concede the point made. If there is a conflict, a clear conflict between the Constitution and the electoral law, of course, the Constitution would trump the Election Act. But that has to be demonstrated. It's not to be inferred. It is not to be assumed. I want to make another point as time is moving, which has been made by other people, and I'll be very brief about it. It's at paragraph 11 of my submissions, and it goes on until paragraph 19. And it is my second limb of submission. Elections are not about politicians. Elections are not about politicians. Elections are not about political parties. Elections are about voters. And to the extent that we develop a jurisprudence that forgets that we held the election in the first place to recognize the sovereignty of the voter to be governed by a government of his choice, then we will make an error. So we need to keep going back even as we ask ourselves, and I'm coming to that as my second last point, when can you upset an election? We must keep the voter in mind. It is his election. It is his will. It is his sovereignty. And I have made that argument at great length there. I will not repeat it. And I want to add in that respect that I have placed before your lordships material showing that the Republic of Kenya, other than in the Constitution and its laws, is party to international conventions and treaties which reinforce her own commitment, the Republic's own commitment to an open, transparent, verifiable election. And I think you could, my lords, when you have a moment, have a great look at that. And I am persuaded by the South African Supreme Court decision in Richer versus Minister for Home Affairs on the vote to right, sorry, I'm becoming dyslexic, on the right to vote and why it's so important for the democracy that we have established here. Now, let me make another point, my third point, and I think it's been made by other people, but I want to share this with you in very brief terms. The election infrastructure in Kenya changed between 2013 and 2017. And it changed to create greater transparency. And I'm happy to see my learned friend James Orengo here, because we spent so much time with him chairing, and I have placed that material before you, chairing with Honorable Kiraitu Murongi, Senator, the Committee of Senate that debated and collected views from the whole Republic on how to make the amendments that are now set out in great detail in my paragraph 20 to 30. And I will not take your time. But what I'm trying to say, my lords, is we have been moving forward in improving the transparency of elections by integrating technology. But it is false to claim that in Kenya we have an electronic voting system. It is manifestly false. And it is unproductive. It is unproductive and unhelpful because we confuse the public. We create this false dichotomy and confuse the public that there is an electronic system that is foolproof, and any manual intervention is suspect. The truth is this, my lords. We have a manual system that has electronic interventions. I made that submission before the Honorable James Orengo. I don't know where he is here. Sometimes the playing field is not very fair because you go to Parliament and you make a submission to the same person, you will meet in court arguing the same case and so on. But that's a story for probably another day. My lords told me not to address the issues raised by the minor KI case. May I seek half a quarter minute to make a very small point? And it was this. The entire jurisprudence of how to conduct an election was changed by the minor KI case. And this was, I think, 2 weeks before the election. And we cannot run away from that. It is so true. And whether it was changed in favor of the petitioners or in favor of the respondents, my duty is to inform you that it was changed in a very radical way. First of all, the chairman of the Electoral Commission was rendered merely, as far as the presidential election was concerned, he was advised that he had no role after the election had been declared at the voting station. So I wanted you, my lords, to just bear that in mind. I will say nothing more. I will obey your injunction on that. Let me come to my last point, my Lord, and I beg you to add me 5 minutes. Okay, my Lords, my two last points are this. When you are told that the election cannot, that in Kenya we have reached a point where a winner cannot be otherwise, his win cannot be impeached, it is not true. It is for failure to appreciate the several petitions you can have. You can have a petition saying the winner wasn't qualified in the first place. An election didn't happen in parts of the country. People who didn't vote, who shouldn't have voted, should voted. Let me then, because you have exercised your discretion, come to the last point, and it is this. My lords, I beseech you to do one thing. Not about this case, because this case has many learned people arguing about it, about the future of our jurisprudence. Stabilize the law. Create continuity and certainty. You are being asked, my lords, today to do what Martin Luther, the great philosopher, scholar, was asked to do. When he appeared before the Diet of Worms to be tried for heresy, he was asked, "Why are you the author of these books?" And he said, yes. He was asked, "Do you denounce them?" And his answer was, "How can I denounce them when they have been perused by pious people all over the world and they have proclaimed their greater spiritual strength as a result?" You are being asked to abandon standards that you have confirmed, not in one case, in 7 different cases. How could you possibly do that without throwing the jurisprudence in a tailspin? I urge you, my lords, many jurisdictions looked up to you for guidance. Keep guiding them. Thank you.
Stand here, Honorable Chief Justice, Deputy Chief Justice, and my lords. And form our republic. For the record, my name is Stephen Mwenesi. I appear with Mr. Omwanza and Mr. Kiari Mungai. I will address your lordships for about 12 minutes, and Mr. Omwanza will address my lords for the balance of the time that we have. We have made our written submissions and our brief, and you have directed our remit. On reflection and upon participating, there is an aspect which is not in our submissions, but which I will touch on. But permit me first, for the record, to state and stress that the Law Society in these proceedings is, of course, on a very delicate, but I'm happy to say secure platform. And we address you as amicus to directly offer a public interest view. We believe that we stand in this august forum with corporate support of thousands of great legal minds, among them the titular head of the bar, the Honorable the Attorney General and his officers, past Attorney Generals, including Honorable Senator-elect Amos Sitsula Wako, leader of the Kenyan Senior Bar, all Kenyan judges past and present, and our magistrates and registrars are members of our society. The second petitioner, Honorable Stephen Kalonzo Musyoka, and his co-principal at NASA, Honorable Senator-elect Moses Wetangula, are our members. Senator-elect James Egri Orengo, and his distinguished counsel for the petitioners, our respected members, among them Senior Counsel Firoz Nauroji, immediate past Ombudsman and MP-elect Otiende Amolo, MP-elect Millie Odhiambo, Professors Shihanya, Mutaka Kangu, and other distinguished women and men of learning. The first interested party, Honorable Kura Court, is a member of our society. The Honorable Senior Counsel Paul Mwite and his distinguished team for the first and second respondents, including Senior Counsel Lucy Kambuni and Professor Pilo Lumumba, are members. And for the third respondent, President-elect Uhuru Kenyatta, we have Fred Ngati and Senior Counsel Mr. Ahmed Nasir Abdullahi and their distinguished team of men, women and men as our members. The learned chairman of the IEBC is an LSK member along with many of the commission staff. We are in a delicate situation. But having declared that interest, our statutory mandate authorizes the Law Society of Kenya to speak for the people of Kenya and to assist the people and the judiciary in the administration of justice. And as amicus, therefore, we hope we can assist. My lords, ours will be a broad-minded approach, and we hope to offer something new, something novel, something different that assists the court in the discussion of whether and how to deal with the matter before it in the context of Articles 81, 86, 87, and the Constitution, and Section 83 being taken into account as directed. Mr. Mwanza will address our written submissions, but permit me very briefly to say this. Article 87 of the Constitution mandated Parliament to enact legislation for mechanisms for the timely resolution of election disputes. Did Parliament enact those mechanisms for the presidential election disputes in the Elections Act 2011 or in the Supreme Court Act 2011? The long title to the Elections Act may be said to, by necessary implication, apply to presidential election dispute resolutions. However, going by this court's decision of 2013, you did yourselves take up the question of what is your jurisdiction. And you held that the jurisdiction of this court flows from the Constitution, Article 140, 163, 3A, the Supreme Court Act, and the Supreme Court Presidential Election Petition Rules, now the Rules 2017. It is obvious, therefore, that the jurisdiction of this court in a presidential election is, in terms of Article 163, 3A, exclusive, original, and it is there to hear and determine disputes relating to the elections to the office of President arising from Article 40. We cannot go beyond that. Therefore, with all due respect to my learned friend, the Attorney General, we cannot fall to the Elections Act, which in Part 7 do not even, where there is the title Resolution of Election Disputes, does not mention presidential election dispute at all. It would therefore mean that on the questions that have been put forward, particularly by my learned friend Mr. Mutaka Kangu, do you revisit Section 83 and the standard of proof and the legal burden? The question does not arise. The whole purpose of the court, as given by Article 259, is to promote the purposes, values, and principles of the Constitution. The purpose of the Constitution has been to give exclusive jurisdiction, original jurisdiction, to the Supreme Court. It is to advance the rule of law and human rights and fundamental freedoms in the Bill of Rights, including under Article 38, upon which much has been said and I need not repeat, and to permit the development of the law and contribute to good governance. So the court would ask itself whether in so important a question as the election of president, it is enough to merely make it appear that the election was conducted according to the principles of the Constitution and the election laws, or that it appears that infractions did not affect the result. Should the court not furnish a standard for constitutional determination of invalidity of the election of the president-elect, the legal burden and the evidential burdens may be relooked and redefined. We may take Section 83 as a guide, as it was obviously taken in 2013, but design an exclusive standard for the Supreme Court and litigants in the Kenya presidential election petition. My Lords, the question you have asked us to address, and which my learned friend will amplify on, is Section 83 relevant to your proceedings? And we are saying no. Is it inconsistent with the Constitution? We are saying yes, as far as a presidential election is concerned. If Parliament has exercised its power at all for presidential elections, then it has done so through Section 12 of the Supreme Court Act, as amended through the Act of 2016. Where is the inconsistency? Article 140 requires this court to determine whether an election of president-elect is invalid. Section 83 is about void elections, and my learned friend will go into the history of that section a bit more. So there is an inconsistency. Invalid is that it exists, but it has been invalidated, it is knocked out, and might be able to be revived. Void has the essence of nothingness. Declare that it is completely gone. So to that extent, it is not applicable, and the invitation to review in terms of that provision is not there. We are saying that the whole question of your jurisdiction is constitutional. My learned friend, Mr. Mwanza, will address you further, and we ask that if at all you feel that in terms of the special peculiarities of this particular petition you need to revisit, you have the freedom to do so. But you have made the law, the Parliament has made the law, the rules are there, and we follow them. I don't think my learned friend, the Attorney General, would disagree a great deal.
Thank you, Senior.
Thank you, Mr. Mwanasi. Mr. Mbati?
Yes, my Lord. The Law Society begins by stating that the test of voiding an election or invalidating it is what the Indian Supreme Court has called the little man test. Yes, my Lord, I'm saying that the test to void a presidential election should be the test that has been applied in India, and it's called the little man test. This is the test of the little man in a polling station with a small pencil who goes and marks a ballot paper and makes his choice known, and consequently elects a leader of his choice. And this ought to be done, my Lord, without fear of intimidation, without corruption, and without undue influence. My Lord, if we've relied on one authority by the Supreme Court of India, and we've want to highlight it. It's at page 38 of our written submissions, whereby the court says that therefore the well-recognized position in law is that purity in the electoral process and the conduct of the elected representatives cannot be isolated from the constitutional requirements. Democracy and free and fair elections are inseparable twins. There is almost an inseverable umbilical cord joining them. In a democracy, the little man, that is the voter, has an overwhelming importance and cannot be hijacked from the course of a free and fair elections. His freedom to elect a candidate of his choice is the foundation of a free and fair election. But after getting elected, if the elected candidate deviates from the course of fairness and the purity and becomes a purchasable commodity, he not only betrays the electorate, but also pollutes the pure streams of democracy. So that our submission, my Lord, is that the test of a presidential petition is the test that is found at Article 136 of the Constitution and Article 140 of the Constitution. But more importantly, is the test that is found at Article 138.4, and that is 34A and 34B, about the numbers of the votes cast and the 25% in at least half of the votes cast in the counties. Now, my Lord, then, is it possible to invalidate a presidential election? There have been various views about this point, but our submissions as the Law Society is that the test actually is found at Article 81, sub-Article E, from Roman 1 to Roman 4. The test is a simple one that should be understood by the little man who goes to the ballot box. And that test is that the election should be by a secret ballot. It should be free from violence, intimidation, improper influence or corruption, conducted by an independent body, transparent, and administered in an impartial, neutral, efficient, accurate, and accountable manner. That is the test that is before you. My Lord, if you have a look at the previous constitution, a presidential election was previously petition, was tested under Section 44 of the previous constitution. And this was through a parliamentary petition, because a president had to be elected through parliament. That is when Section 28 of the repealed Act was applicable. However, post-2010, my Lord, the Constitution established the Supreme Court with a special jurisdiction to try presidential petitions. So our submission, my Lord, is that the test that is under Section 83 is not applicable in this case, because that test would ignore many of the fundamental principles that have been set out in the Constitution. So it is possible, yes, to invalidate a presidential election, for instance, on questions of disqualification or qualifications, or on questions of the purity of the process. And my Lord, in terms of the burden that is upon the petitioner to prove, that burden should be the constitutional burden equivalent to the petitions that are presented before this court. And that was the decision that was made by the High Court, if I remember, in the case of the boundary cases, that if you present evidence that is to the satisfaction of this court that there were infractions of the Constitution, then a presidential election can be voided or invalidated. So we are relying on our submissions because of time. I will not be able to go through them, but the point we wish to make is that the language in the Constitution is that this court invalidates a presidential election, whereas under Section 83, it voids. So those are contradictions in terms of art. My Lord,